Okay, so for the recording purpose, let me start again. So we'll be discussing about contract transformation, shape shifting clauses, wherein we'll be discussing about various types of contracts, industry specific contract consideration, and visible part of
Ma'am, your voice is breaking.
uh, is it better now?
Now it's
Any
fine.
better? Yeah.
Yeah, yeah.
Thank you. Yeah, please let me know if my voice breaks in between. Okay. Okay, so here you can see the iceberg of contract. So here it is only the visible part which is visible to others, that is the contract that you have drafted. But the invisible part, which constitutes about 90%, that includes your language proficiency. Here you have to be very good in the language that you are drafting. It can be Hindi, it can be in Kannada, it can be in Tamil, or it can be in English. Whatever language you draft the contract, you should be having good hand over it. Followed by tax laws. Yes, you can see wherever there is consideration, there is taxation. So you should know about tax laws, ADR laws, alternate dispute resolution laws, market research, like what is going on in market, what is the trend, what is the new laws that are there, advertising law, technical skills, as if you're working in a platform, you should be knowing that how the platform work. It may be SAP Ariba, it may be Syrian, Adobe, DocSign, CX tool, so many tools. Even for that matter, Microsoft Word, corporate law, understanding the expectation of client, like you know what your client wants, knowledge about market trends, what's happening in market, intellectual property right, the client meeting. Yes, the gesture of yours also matters a lot. You should be presentable. Insurance law, soft skill. Yeah, you should be very good at your communication. Okay, you should be very good with your body language and other soft skills. Eye for detail. Yes, you should be reading every single line, even a comma, a full stop, everything. You have to be wetting it very, very in depth. Technology laws and concepts. Yes, not just law related to technology, but concepts too. Now suppose if you're drafting a software transfer agreement, you should be knowing how the software would be transferred from one platform to the another platform. And even if the ownership is transferred, like what is the technicalities that is involved in it, so that you can add all of it in the contract clause. Consumer laws, industry specific laws. Now, if you're working for a banking client, you should be knowing laws related to bank. If you're working to a hospital industry, you should be knowing related to the hospital, and so many others. And subject knowledge. Yes, apart from the law, you should be knowing what the subject is. Now, if I say a software agreement, like what is a software and what is required for that one, and why would the business need it? So all the things you have to be aware of. And negotiation. Yeah, you should be well aware of the negotiation part. Either it may be the business clause or legal clause. You should be able to present yourself in the better manner. And the contract laws. Yes, certain part of contract laws are visible for the others and certain are not. I have kept it like that because there are many laws wherein we believe that whether they have to be read hand in hand with the contract law. For example, your corporate, the Companies Act of 2013, Competition Act, all of these has to be read along with the contract laws because they also specify certain clauses. Like if you want to draft a merger and acquisition related agreement or an assignment or a novation, then a lot of clauses from Companies Act and from Competition Act do apply to that agreement. So you have to be aware of those clauses too. When I say contract law, it does not only mean that the Indian Contract Act, but it also includes many other laws that are existence in the Indian system as well as in the international platforms. So this is the bird's eye view of the uh, in-depth knowledge that you should possess to be a good contract drafter or a good contract reviewer. So I could tell that yes, you should be um, uh, jack of all, even if the master of none. Like you should be knowing a little about everything. You cannot skip that. Oh, I am interested in corporate law, I am going to have a corporate job, why should I study IPC? No, 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 you should study IPC because you should be knowing what do you mean by defamation under 499 and IP 500 IPC. What do you mean by criminal intimidation? What do you mean by 420 cheating? And how can that be included in your contract? Suppose if somebody cheats in the contract, whether it will be attracted under 420, whether somebody defames, can or somebody does anything, can that be added in the contract 499 500? So you should be knowing about everything. You cannot just skip on any subject of law for that matter. Moving next. Okay, moving next, I have made some laws, some industry specific laws. So the first industry that I have is banking and finance. So along with the Indian Contract Act and other major legislation, you should be well aware of Banking Regulation Act, SEBI Act. So if you're drafting any contract related to banking and finance industry, if it is related to any taxation part, like every contract will have taxation part, right? So you should be knowing if Income Tax Act is applicable, GST is applicable, Security Transaction Tax, SST Act. So is that applicable? So this is wherein stocks, derivatives, and stock exchange. If you are drafting any contract related to that, then you will have to be aware of Securities Transaction Tax Act 2004. And if it is any insurance clause, then you should be well aware of Insurance Regulatory Development Authority, IRDA. Telecommunication, then you should be aware of TRI. Like if you are working for any service provider or you're working with any service provider for that matter, you should be aware of this one. Information Technology Act, IT Act, you should be knowing that if it is related to some software or cyber security, something like that. You should be knowing about data protection laws too. Now recently I couldn't recall the name of the company, but the employees of the companies were accused of data leakage. Like they were collecting data, they were software engineers, they were collecting data and they were leaking it to some competitive firm. So so you should be aware of data protection laws in the employment agreement if you ever drafted, followed by IP, like Patents Act, Trademarks Act, Copyright Act, etc., etc. So these are some of the basic, I could say, industry-specific laws. Now, if you go to the food, you have FSSAI, and you have enactments like Infant Food Milk Substitutes and Protection Act. So you have those kind of legislation which you should be looking into. And if it is hospital industry, then you have Medical Council of India Act, you have Biomedical Waste Management Act, and you have this Water Act. Even that is applicable there because and also this Environment Protection Act, even that is applicable because you will be using some hazardous material. So all of these things has to be kept in mind while drafting the contract. Now, if you can ask me that we should be studying all the time, we should be knowing everything, I would not be telling you that you should be pro at every legislation. Now, if I tell IT Act, I am not expecting as a contract person to tell you that, yes, tell me what is Section 16. No. But as a contractual person, you should be least aware that, yes, there is a law like this. Okay, now, for example, we have Indian Tolls Act, which authorizes the toll authority to seize the vehicle just in case or seize the value, any material which is equal, which has equal value as that of the toll amount that is to be paid. It has that particular power. Okay, so this such kind of legislations you should be knowing. And one more example I could give you: Treasure Troves Act. Okay, so as per the provision of Treasure Troves Act, it says that if you find anything under the ground, which has the value of more than 10 rupees, that is considered as a treasure, and that has to be given to the government. Okay, that has to be given to the DM. So the value of that, something we find beneath the earth, it has to be like, it starts from 10 rupees. Okay, so if I find a gold coin, like a small piece, which is considered to be a treasure, which is not mine, then I have to give it to the government. Okay, so I will not tell you that you should be again knowing all the provisions, all the sections. No, but you should be knowing. Yes, somewhere in the world, somewhere in our legislations, there is a law for this. So there is something that is speaking about this, so that whenever you get a opportunity, or whenever you get into a circumstance wherein you have to draft that contract, you can go back and you can read it. Okay, I do understand that we are all humans, so it is not possible for us to remember each and every legislation, but at least know it. Okay. And how will you know it? You can go to the government websites like indiacode.nic.in, or you can go to the websites like governmentlegislations.nic.in, I believe. So there you can find list of all the legislations that India has in force currently, so that you can have a rough idea that, oh, we have this enactment, we have that enactment. So somewhere or other, whenever the circumstance come, it will be clicking to your mind. Now, so this was all about the industry specific laws, a brief intro. Moving next, we'll be studying about various contract types. Now here I have taken three things. The first one is SLDMA, Software License Development and Maintenance Agreement, followed by SaaS, Software as a Service, and Software License Agreement. Now you can tell me that it is all same, it is all related to the software only. And how do we decide that what circumstances we are using it? I have put the notes here so that when I share the PPT, it will be easier for you to note down it or understand it. So SLDMA is wherein the software is given, a license is given, the license is developed, and they are maintained. Okay, so this could be a customized software that is given for you. Okay, so it can be you are further maintaining it, you are giving the support, which is something which is very exclusively for your usage. Wherein software as a service is a cloud-based application. Like you are, it is not, but it is given by a third-party provider. You are not owning it. They are not giving you the license to use that, but you are accessing that platform, and over the internet you can use it. Okay, that is software as a service. Wherein software license agreement is wherein that is not something, I could say, a customized one. That is wherein a general software is given to everyone and they use it as per the terms and conditions. Now, like whenever you download an app, you will find software license agreement. Okay, so wherein it says that yes, this is a software that we provide. We may upgrade it or we may not upgrade it. It is up to our discretion. But this is a software that we provide to everyone. So you are given the license to use it. So it does not cover the development and maintenance part very specifically. It can be done or it cannot be done. They are at that discretion. Okay, so I hope this three differences are clear. Software SLDMA is used wherein the software is very custom made. Majorly it will be custom made, and it will have the development and maintenance clauses. Like the software will be developed, will be maintained, updated, so the supplier will provide all the end-to-end support system. Followed by SaaS. SaaS is wherein you are using a third-party window, and over the internet you are accessing that particular software. That is called as software as a service. Now, for example, you are using any translation. Now you put a line in Kannada, you put Kannada in English, it will come in Kannada, or in Hindi. That is a web-based thing. You convert this PDF to Word. You're not downloading anything, right? You are using the software online. That is software as a service. Wherein software license agreement is something, the software is given generic and it is downloaded. For example, Tally, Zoom, Google Meet. So there you will have this software license agreement. So based on the client's specification, based on the business justification, like what is the scope that they are explaining, you will have to either select SLDMA, SaaS, or software license agreement. Is this clear to you? Do you want me to repeat this? Yes, no.
Ma'am, what's the purpose of studying these differences? Like only these.
Yeah, I'll tell you. Now, for example, you are working in a firm as a in a company as a contract negotiator or contract lifecycle management. Okay, you are a contract specialist. Now that business will come to you and they will not tell you that they want an SLDMA, they want an SAS, or they want an SLA. They will come and just give you the brief that this is the purpose, and for this we want to execute a contract. Now, being the contract specialist, you are the one who will be selecting the template that are you going to execute SLDMA, are you going to execute SAS, or are you going to execute SLA? Even if you work as a freelancer, even then they will not be telling you that I want this specific contract. They will just tell you that, yeah, I want a contract for this and this purpose. There you will have to select which contract type are you going to choose.
Okay, these three will be restricted only to the software or the
Yes.
technical
Yes.
contracts, right?
Yes.
Okay.
So these are only the contract softwares. Like if you in Google, you can find so many templates, you can go through it. So it will be all about the softwares. So how the software will be transformed and will be given from one person to another, what will be the pricing and how the milestones are decided. So if you read the template, you will have more idea on that one. Like all the companies, if you're planning to working on a corporate thing, you will not be actively involved in the contract drafting, but wherein you will have to do little tailoring job, but majorly they'll have the templates ready. All that you have to do is select a proper template. Yes, this one applies here and I'm going to select this one. Okay, and you have to fill all the business justification in that particular contract.
Okay, ma'am.
Okay, is this clear? Yeah, moving next, we have one more. This is SOW. Okay, so now the whatever we drafted here is MSA, that is Master Service Agreement. Now we'll have the SOW. So your master service may be a professional service agreement, a consultancy agreement, or what I could say, a service provider agreement, whatever agreement for that matter. And SOW is the subsequent contract that is executed. Okay, so your MSA will say that we are going to provide so and so services and so everything. SOW will say what exactly we are going to provide. So this SOW is divided into three types. Okay, the first one is there are further SOW types, but these are the three main kind of SOWs. First one is fixed price SOW, that is time and material SOW, and turnkey SOW. Fixed price SOW is wherein, see, I am going to take 4 classes to you on contract drafting. So the fees for that 4 classes would be 1,500. This is fixed price SOW. Okay. And then time and material SOW. So there I will tell you, I will be taking 4 hours of class to you. And if I take 1 hour extra, then I would be charging 500 more. And per hour, I will be charging 200 rupees. And also, if I have 2 lectures, I will have this many charges. That is called as time and material. So I am charging based on my time I am charging based on the materials that is provided. That is called as time and material SOW. Turnkey SOW. Turnkey SOW is wherein in the 4 days of period, I will make you the expert. So once that expert thing is done, you will pay me. That is called as turnkey SOW. Okay. So in fixed price SOW, you are going to have a price fixed that in this price it will be done. Time and material, it will be like you will pay for the time and also you will pay for the material that is invested. Turnkey SOW is wherein I don't know what you are going to do, but at the end of the day, I want it to be delivered for this much of amount. That is called as turnkey SOW. So the difference between fixed price and turnkey is the price may vary in the turnkey SOW. Okay, so it can be higher or it can be lower. It will be depending on the nature of the work that is done. But you are going to get the final product under any circumstances. That is called as turnkey SOW. So these are the three kind of statement of works that you can find in the regular usage. Majority of the times, I have, in my experience, I have not even seen turnkey SOWs used. Majority of the times, it will be fixed price SOW or it will be time and material SOW. Okay, so these are the statement of works that you'll have to do. Now, again, you imagine you are a contract specialist or you are a freelancer. Now the client will come and tell to you that, see, I have to, this is the professional service agreement I have, and I have to execute an SOW which says that I'm going to pay him 5,000 rupees and he will be delivering the goods to Hyderabad. Now there it will be fixed price SOW. Okay, so if it speaks of time and material, then it would be like he would be charging 4 rupees per kilometer, or he would be charging 400 rupees per day, and he would be covering that distance. Like what, one day it will be 400 rupees. The moment he reaches Hyderabad, he will stop and I have to pay. That is called as time and material SOW. Okay, turnkey SOW would be, I don't know, what you do, at the end of the day, goods has to be reached to Hyderabad and then you let me know the money. That is called as turnkey SOW. Okay, so in those circumstances, whatever the clients gives you the input, you will have to select the kind of the SOW template as such. Or if you are like a freelancer, then you will have to draft it just in case if you don't have the template ready. Is the SOWs clear to you?
Yes, ma'am.
Okay, thank you. Moving next, we will see some example. Hey, I want to add a clause in my consultancy service agreement that my client will not badmouth about me and post negative reviews. Is that possible? Okay, so this is the reference that I gave earlier. So here, consultancy service provider service agreement is where that one party is giving these services to the other party. Now here they want to add a clause that the person whoever has received the service will not post a negative review, that don't go to them, they are very bad, I had a very bad experience, or share negative reviews if there is any cross verification or something like that. Can we add a clause that says that the client will not do such things? Is that possible? The answer is yes, it is possible. So it is possible through this non-disbarment clause. Okay, so here it means that this person will not be expressing any kind of negative opinions, even if they are true. Okay, now suppose, for example, you did not like my class at all, but when you joined to my class, I have added a clause called as non-disbarment clause, and I have said that you will not badmouth about me. So you will not be posting any kind of negative reviews. For that matter, we don't have that clause, but still, like if there is something, then you will not be able to. You are bound with the contract that you will not be doing. And also this includes truthful review or facts about the other party or the other person. Okay, and now you can ask me what is a constitutional valid? This is constitutionally valid. Now again, this is a very debatable topic. There is like there are discussions going on around this clause, that can you add such a clause which states that they will be curtailed from telling their express from their genuine opinion, and this is contradictory to the freedom of speech and expression. So many discussions going on, but still you can find this clause in many of the contracts. Now, the similarly, we have defamation clause. Now, what is the difference between defamation and disparagement clause? Is that defamation is something which is constitutionally valid, and wherein the person is making false allegation. Okay, they are defaming using the false allegations or representations that is made by the other party. Wherein disparagement, you are like bad mouthing about that person. Okay, like you are telling that true genuine experience that you had faced from those people. Okay, so this is possible in the contract, that you can draft a disparagement clause and you can add in the contract. So whenever your client, or whenever your whom I can say your manager or who your vendor, whoever it is, comes up with a unique demand or unique question, don't give them the answer straightforward that no, this is not possible. As far as my experience is concerned, I have seen that in contract any clause can be given the color of the legality and can be peeped in a legal manner. Now you can see that, like when I got to know about this clause earlier, I was like, my God, how can this be there? Like, is it legally valid that you cannot allow someone to tell the truth or tell the facts or share their experience? Yes, that is not possible with this kind of clauses. Okay, so do not rush and give an opinion. Do little research, do little study of the clauses that are relevant to that, and somehow you can color it and you can have that in the recipe of the contract. I hope this clause is clear to you. If you have any doubt, you can visit my LinkedIn profile. This snippet I have taken from my newsletter. So I have posted a detailed description of these two clauses, so you can read it there. And also, if you have any questions now, you can ask me.
Ma'am, how is the remedy for this non-disparagement clause can be seeked, ma'am? Like, since it's
Breach
not been
of contract.
recognized
Breach of contract.
yeah, for the remedy, in the sense, like,
Yeah,
if there's a
this will be surviving the termination of the contract.
okay.
Yeah. So this will be included in the list of the clauses that survive the termination. Like you have this confidentiality clauses, right, which survive the termination of the contract.
Yeah, okay.
Yeah, the same way, even this one, and then you can ask them for compensation.
Okay.
That you have done the breach, like the same way you instigate a suit for breach of confidentiality information, you can invoke the same provision here.
Okay, ma'am.
Yeah. So moving next. Hi, this is a snippet that one of the conversation with client. One of the agreement that I have entered with my client will expire on 20th November 2023. Should I be doing contract renewal or extension to continue the services? So what do you mean by contract renewal and the contract extension? Both are different terminologies. Okay, I will tell you why terminologies are very important in the contracting world. I once upon a time I had attended an interview for the contract manager role, and the interviewer was asking me about the roles that I have done and other things. And instead of telling the word supplier, I used the word customer. Okay. And that did not fit convincingly with that person who was interviewing to me. He said to me, Kritika, you have to be very clear here. Now, if that is a supplier, then we will be paying to him. And if it is a customer, he will be paying to us. So there is a lot of difference between supplier and customer. So you have to be very clear while referring in your sentences. Either you are referring a supplier or you're referring a customer, or if you are referring yourself as a customer and the other one a supplier, you should maintain the same flow throughout the contract, so that the person with whom you are speaking is very clear, and it is very uh, unambiguous for him to understand, are you referring yourself as a customer or supplier? That was something which was eye opening to me, and I'm like, that stuck in my mind so hard. Like, I was like, oh my god, how can I make such a mistake? Okay, so the same way is contract renewal and contract extension. Though we sometimes feel that, hey, what is the difference between those two things? But they carry a lot of difference. Now let me tell you how, what is the difference. Now contract renewal is wherein you renew the contract. Okay, that is the contract. For example, this contract is will be expiring on 20th October 2023. That is, I renew it, like it will continue for another one cycle. Okay, wherein contract extension is, you are extending the period. Instead of the contract expiring on 20th November 2023, I will be pushing it till 15th of December 2023. That is called as contract extension. Renewal is wherein you are doing it for the same cycle again, wherein extension is you are extending that date. Okay, so now while speaking, also you would have listened people telling the classes got extended. Okay, it will not be the classes were renewed. No, it will be like the classes were extended. That is, it was supposed to expire on 20th November 2023, but it got extended till 15th December 2023. Wherein, if it has to be the renewal, then it would be the contract will be expiring on 20th November 2023, and it is renewed for the another 1 year of period. That is until 19th November 2024. Okay, so this is the difference between contract renewal and contract extension. So while drafting the contract too, you'll have to be very clear while writing whether it is a contract renewal or if it is a contract extension. Majorly, if it is related to any building construction or any fixed manufacturing, then it will be like contract extension. Okay, the contract would be extended for the another 6 months of period, or any services also for that matter, it will be extension. Wherein in the cases of subscription, licenses and other things, it would be contract renewal. That is, a contract would be renewed, the subscription would be renewed. Okay, so is this clear, the difference between contract renewal and contract extension? Do you want me to repeat this again?
No, ma'am.
Okay, yeah. Moving next. Okay, so I have the answer ready. I think I pressed the button too hard. Okay, so here the question is, the organization is implementing modifications to the employment benefit plan as outlined in the document. However, a crucial concern arises regarding the fair and equitable treatment of existing employees who are currently receiving unemployment benefits or have already incurred a disability as of April 30, 2023. The challenge is to establish a clear and comprehensive clause that ensures these specific employees are exempted from the proposed changes, maintaining the continuity of their existing benefits and addressing the potential impact of the modifications of their employment conditions. The objective is to strike a balance between implementing necessary adjustments to the plan and preserving the rights and entitlements of the affected employees, thereby fostering a smooth transition of all parties involved. See, this states that with this effective date, the changes will be done. But till this date, if somebody is receiving the benefits or somebody is under this particular clause, then they will be getting the benefit. Okay, so that is what this paragraph means. Okay, so it says that there will be changes in the employment benefit plan, but that changes will not be applicable to anyone who has got any disability or who fall under that one till April 30, 2023. So this will have the prospective effect after this particular date. So for this one, we will be adding grandfather clause. This is also called as legacy clause. Okay, so this reads as, this is the template that I have extracted here. The modification to the employee benefit plan described above shall not apply to any employee who, on April 30, 2023, either is receiving employment benefits or has incurred a disability with respect to which employment benefits subsequently become payable. Okay, so they have reduced some of the provisions in the employment benefit plan and has said that till April 30, 2023, whoever is falling under the previous plan, whoever attracts the applicability of that plan can avail those benefits. But after that, they will be having the, if anybody witnesses any incident after that, then they will be given with the, one second, I think there's someone trying to log in. Okay, so they will be given with the benefit at the later part. Just give me a second. Yeah, okay. So this is called as grandfather clause or the legacy clause in the contract. And also I'll be sharing the PPT along with the recorded session. So once this is all done, maybe on Monday, I'll be able to give you all the details. Along with that, I'll give you some more insights on the clauses that we discussed today, that is grandfather clause and all other clauses. Okay, moving next. We'll have to draft one more clause, that is, let's read the question, what it says. Craft an ambiguous termination clause in a business contract for change in control event poses a challenge. The objective is to define specific triggers such as changes in ownership, mergers, asset sales, and board composition alterations, and ensure a clear, enforceable process for contract termination within 30 days of notice period. The challenge involves addressing complexities, ensuring practicality, and minimizing potential disputes, ultimately aligning the termination process with the interest of both the parties. Now here, what you would understand from this one is, so if there is any changes in the contract parties, like there is changes in the ownership, it is merged, it is acquired, or the property is sold, or board composition is changed, whatever it is, then it is the ground for termination for the other party, and the other party has to give 30 days of notice and can end the contract. So now we'll have to draft this clause. So now this clause will be titled as change of control. Okay, so this can be even given the title of assignment, novation, but combined everything together, we have change of control, which is more wider than that of the assignment and novation. Okay. Change in control. In the event of a change in control as defined below, both the parties shall have the right to terminate the contract by providing a notice of 30 days. That is, if any change happened as mentioned in the 4 clauses A, B, C, D, then by giving 30 days notice, the contract can be terminated. The acquisition by an individual entity or group, the acquiring party, of a beneficial ownership of more than 50% of the voting power of outstanding securities of the company, the consumption of a merger or consolidation involving the company where the shareholders of the company immediately before the merger or consolidation do not own directly or indirectly at least 50% of the voting power of the surviving entity immediately after the merger or consolidation, the sale of all or substantially all of the assets of the company, or a change in the composition of the board directors of the company such that the individuals who were directors of the company cease to constitute a majority of the board unless the election or appointment of each new director was approved by a vote of at least two-thirds of the directors then still in office who were directors of the company at the beginning of the period. So it has mentioned the four clauses. Okay, the first one is if the acquisition is done for more than 50% of the company ownership, that is 50% of the voting power is gone, or any merger or any acquisition or any kind of consolidation that has happened, and again wherein 50% of the ownership is lost. Third one, the any of the asset or all of the assets of the company are sold, or the board of directors of the company are changed. See, now you can see that the voting power, etc., etc. So this is wherein the directors are voted amongst themselves. So that is done so that no new person, no much of new persons would be in that board of directors are added. So these four circumstances would be the change. Okay, so change of control clause, and this if any of these four clauses happen in that particular contract during that validity of the contract, then the party shall terminate by providing a notice of 30 days. Okay, this is similar to that of the assignment and novation. So I hope you are clear about the difference between assignment and novation. If not, let me tell you again. Assignment is wherein I was supposed to take the class, but because of my non-availability, I have given my class to somebody else. That is called as assignment. Novation is wherein I am totally replaced. Okay, I am no more there. You have registered to this contract conjures workshop, and then suddenly that is replaced with something else. That is called as novation. Okay, so wherein you are replacing one party with that of the other party. Assignment, wherein your existence is still there, but you are reassigning it, you are subletting it. That is called as assignment. So in change of control, you can find both the some of the terminologies of both the assignment as well as the termination clause. I'm sure if you are hearing this for the first time, or if you are reading this kind of complicated clause for the first time, then this would be sounding little French and Latin to you. But trust me, when you give it about 10th or 11th read, it will require, you will be able to understand. And also if you read it along with the contract, right, you will be able to connect the dots and understand what is this change of control exactly is. Is this a little clear to you? Have you understood a little?
Yes, ma'am.
Okay. Yeah, moving next. Draft a legal provision within a contract explicitly states that the agreement represents the complete understanding and arrangement between the involved parties, overrides any prior or concurrent agreements, and requires written consent for both parties for modification, for any modification or amendments. I am sure all of you would have come across this particular situation any of the time, right? In anything that you do. Now, this clause is not usually named, and it will be at the fag end of the contract. So the title of this clause is integration clause. Okay, the integration clause reads as the agreement constitutes the entire understanding and agreement between the parties hereto and supersedes all prior and contemporaneous agreement, whether oral or written, between the parties relating to the subject matter hereof. This agreement may not be amended, modified, or supplemented except in writing and signed by both the parties. To the extent that there is any conflict or inconsistency between the provisions of this agreement or any other documents or agreements referred to in this agreement, the provisions of this agreement shall prevail. No party has relied on any representation, warranty, or agreement of the other party except as expressly set forth in this agreement. This agreement may be executed in counterparts, each of which shall be deemed as original, but all of which together shall constitute one and the same instrument. Okay, so this one you will find in every contract. And the title of this particular clause is integration clause. So now the first part of it, it says that this particular agreement will supersede all the previous oral as well as the written agreement, and only this shall prevail. And any amendments or any modification or any supplements, either it can be amendment or addendum, everything will be in writing and signed by the both the parties. Okay, when I say addendum, it is you are adding to a contract. Okay, amendment is you are making corrections in the existing contract. Okay, there is no addition in amendment. It is making correction, like using the whitener and making correction. Addendum is adding a new sheet to it. Okay. And the next part of it says that if there is any conflict or anything, whatever written in the contract, in this contract, it will be final. And no parties has relied on any representation, warranty, or agreement. See, representation and warranty. Representation is wherein you tell them that this was there and you show them the examples. Okay, now for example, I'll show you the review. See, this is the review that we have for IAPS India, and this is what the students has to say. That is representation. Warranty is wherein I tell you that, okay, if you don't understand, I am going to give your course money back. That is called as warranty, and that is not exactly warranty. You are not getting replaced. Warranty is a bit part of that one. Okay. So that is called as warranty. You will be given subsequent trainings till you get satisfied that you have learned it, till you become expert in the contract. I am going to teach you. That is called as warranty. Okay, so it says that except whatever representation we have given in this contract, whatever warranty was provided in this contract, there is no other representation or no other warranty as provided by the customer. Okay, and also it says that the agreement will be executed in counterparts. That will be multiple parts. Like everybody will have an original. Okay, so whenever we execute agreement to sale, it will be executed, and also rental agreements, it will be executed in two copies. One copy will be with the owner, and the other one copy will be with the tenant. Okay, so that means that both of them are original and both of them will be with you, one copy with you and one copy with me, and they are not different copies or different things. They together constitute the same instrument. Okay, so this clause you will find in every contract. Every contract apart from the e-signed ones, because every e-signed ones will be considered as like the downloads, and they will have the copies. So the question of originality doesn't come there, but wherein if it is a wet signature, then yes, there the question of counterparts obviously arises, and you can find this one. And as I said, this clause is a mandatory clause in your rental agreements, sale deed, and other relevant ones. Is this integration clause clear to you? Do you have any doubts? Because I'm sure this is the common clause that you can find in every contract. Any doubt on this?
No, ma'am.
Okay, yeah, thank you. Okay, yeah, this is what all I had for today. So any question on today's session? Like I covered, let me brief you like what we did today in 5 minutes. So we studied about the contract laws that we have to know. You should be master of, you can be master of none, but you have to be jack of all. You should be knowing about everything that is existing on this earth. If not mastering it, you should be knowing that yes, there is something like this happening somewhere, or there is some law like this, or at least or like before coming to a conclusion, a cross verification that yeah, there is something related to this or not. And some industry specific legislation, yes, whatever industry that you are drafting the contract, you will have to be aware of those legislations. Okay, in corporate we use the term categories, okay, wherein we have IT category, fintech, professional service, real estate, we have a technical one, we have consultancy services, we have HR category, and we have different categories are there. So they are like, they are specialized, they'll differentiate people and tell that yes, you have to be expert in this category, that means you should be well aware of these laws. Okay, and also there is category for insurance, there is category for taxation, so that whatever is related to tax part, they can take the cognizance and they can decide the contract, they can decide on the clause. Followed by, I covered various type of contracts, like when to choose SLDMA, SaaS, and software license agreement based on the inputs that you have received from the business. And then we discussed on SOW, kinds of SOW, and we discussed on certain imaginary conversation that could be happening with the client and their demands. So contract renewal, contract extension, the difference between that, grandfather clause or the legacy clause, followed by change in control clause and the integration clause. And in tomorrow's session, we'll be studying about some best practices, and also we'll be drafting some other clauses, and also we'll be looking at certain technical stuff which is very important while drafting the contract in Microsoft Word, wherein the automatic paragraphing, numbering, page number, indexing, and all of the other things which would help you to uh, draft a contract with very least errors. Okay, and which would automate your the drafting process even without a great tool. So Microsoft, we'll be leveraging Microsoft Word like for about 30 minutes, and the other 30 minutes we'll be discussing about some more other clauses. So do you have any questions on today's session, or do you have any specific input, because tomorrow will be the last live session? So is there anything that you expressly expect to be covered in tomorrow's session? Yes, no?
Ma'am, I'm a first year, first sem LLB student,
Mm-hmm.
for more specific. How to approach contract at this earlier stage of LLB?
Yeah. So now, for now, I would suggest you to read the contract templates.
So
Okay,
where
so
can I access those templates in the sense? Is there any online source or?
you do one thing, do not actually rely on templates, but do read the existing service license agreement. Now, for example, if you go for this iPhone policies, they are really good. Okay, so you read those terms and conditions. Whenever you download an application, you just click on that click wrap signature and you accept it. Do not do that. Read that clause, read that agreement, see what does it says.
Okay.
Okay, so that way you can really improve your vocabulary, contractual vocabulary, and also the contract legalist, the contract language, you will be able to understand more. That is the only way by which you can study. Like, you have to experience it, because this is not something that will be taught in your law college. Let me make it very clear. You and I did not study, and for that matter, whichever college you studied, this was not in the college syllabus.
Right, ma'am.
Yeah, this is something that you learn out of your experience. So to get that experience, do read the contracts that are in place. Now, suppose that if the two companies are merging, then there will be a merger agreement. Okay, so that agreement you can get access to, and you can read what is the terms and conditions under which the merger has happened.
Okay.
Now there will be a loan agreement from Axis Bank. If you search Axis Bank loan agreement, you can find the loan agreement. Do read that loan agreement. Understand what does it says.
Okay, ma'am.
Yeah. So that is the best way of learning.
All right, ma'am. Thank you.
If there are no more questions, I think we can wind for the day.
Thank you, ma'am. Thank you for today.
Thank you. Thank you so much. Okay, so we'll meet you tomorrow. Thank you. Bye bye.